We represent a lot of clients who are charged with possession of drugs or trafficking in narcotics at all levels, right from minor possession charges right up to conspiracy to trafficking, pounds and pounds of cocaine. And every client who comes to us, the first question is, will I be able to get this charge dropped? What are the strengths and weaknesses of the case? What are you going to do, Mr. Kruse? I mean, I'm desperate. I mean, some clients are facing years in jail, obviously, on serious charges, whereas others are facing more minor sentences. So what's the strategy? What do we do as a lawyer? Well, the first thing we do, of course, when you hire us is we order the police reports, the disclosure. We need to get all of the evidence the police gathered, any documentation, surveillance, wiretaps, surveillance, videos, you name it, analysis of the drugs, search warrants. I mean, these packages can go on for sometimes thousands of pages, in a more minor case, like 100 pages or so. The Crown Attorney is required to give us all that documentation, the disclosure, what you're facing essentially. I sit down, and the lawyers and I, if they're one of the other lawyers representing you, and review that carefully. We have to pore through it, analyze it. Sometimes that takes many hours. Even on a minor case, it's going to take several hours to formulate a proper legal opinion about the strengths and weaknesses of the case. Did the police make mistakes? Are there weaknesses? Are there charter issues? Are there search issues? There's just a whole host of potential defenses to drug charges. And then once I've completed that process, which can take anywhere from a day to multi-days, depending on the case. I mean, I have represented people with thousands of pages of documents on wiretaps, and that takes days and days to review. But let's talk about a minor case. I mean, I'd probably review it in quite a few hours. Then I sit down with you and start reviewing it with you. Provide the legal opinion. Are there defenses here? What can we do? What's the strengths and weaknesses of this case? What are the odds of you winning at trial? And I can basically give you basic odds within, this is a slam dunk Crown case. There's no defense. They caught you red-handed. Or it looks pretty good for us. We've got a good search issue. It's not slam dunk, but it's certainly higher than 50-50. Or, you know what? We've got some issues that could go either way, depending on the judge or jury who's listening to this case. Or we've got a chance. I think the Crown's got a better chance than us. Or, you know what? It's a strong Crown case. I'm obviously hopeful of finding flaws in the case that I can then approach the Crown on to try and drop the charge. So we receive your full background, and it's always advantageous when you have no criminal record, you're a person in good society. We're going to talk about your background. I sometimes spend an hour or two getting a life history from the client because I want to review that with the Crown. That's important, especially for a good background. And I'm going to tell you the approach that I'm going to go with the Crown. I'm going to say, look, I'm going to try and get the charges dropped because we got a pretty good chance to win. If they won't drop them and they don't offer us a great deal, you should probably just head to trial because I think we can win, although there's risks. There might be a 75% chance of winning, which means there's a 25% chance of losing, but let's see if the Crown will drop this. So I start meeting with the Crown. I got to be very careful what I say to the Crown because mistakes that the police make boil down to different issues that some of them can be fixed, frankly. So if there's something flaw or technical issue in the disclosure that a police officer could fix or the Crown might be able to fix, and I won't give examples, but there's too many examples to even list, I won't disclose that with them. I'm going to say to the client, if we tell them about that technical issue is going to be gone. The officer can cover it off in their notes. They can explain why they forgot to do that somehow in a clever way. Because right now it's a problem and I think we can win. I might not disclose that with them. But there's other mistakes that the police make that can't be fixed. And there's no problem with me discussing that with the Crown. So you have to know as a defense lawyer, I think you learn very early on in your career what to discuss and what not to discuss with the Crown. I mean, I'm sure I learned that maybe the hard way as well. When I was a Crown, actually, you learn a lot of these things. I was a Crown for the first 4 years of my career and then a young defense lawyer. I hope I've learned a lot since then too, over the last 33 years, I think I have. But you never repeat your same mistakes. If you've ever in your career as a defense lawyer disclosed a flaw in the case that came back to bite you, you'll never let that happen again, believe me. So I sit down with the Crown. If it's a mistake that I can review with them, I know they can't fix, I'm going to point it out to them. I'm going to argue, hopefully, there's no reasonable prospect of conviction. That's the test. If there's no reasonable prospect of conviction and it's not in the best interest of the public to proceed, the Crown should do the right thing, withdraw the charge. Sometimes they do and sometimes they don't. Sometimes the Crown goes to trial even when they've got a weak case because it's easier for them politically sometimes to run a case, isn't it, unfortunately? So that's a great result if we can just get it withdrawn outright. Now, another great result is if we can get the charge diverted, meaning, do some counseling, upfront counseling, charitable contributions, community service, and get it ultimately withdrawn. That's a wonderful result. No criminal record. Sometimes a conditional discharge is a great result as well. Depending on the case, it results in no criminal record. The Crown's often willing to give a conditional discharge even on a half-serious offense if there's no, if they think they've got a weaker case. So it's all about plea bargain negotiation. A skilled lawyer is able to do this. They know what to say to the Crown, when to say it, when to pull back, when to plead, when to go to trial, when not. You've got to hire the right lawyer for this. And that lawyer, if they're able to, depending on the county, in some counties, you can pick the Crown that you're going to meet with. You've got to know your county. You've got to know your Crown. In other counties, you can't. I mean, some have systems where it's randomly assigned. The federal prosecutor's office randomly assigns, and they won't tell you who you're meeting with. But I know the counties, and our office does, our other lawyers, where we could actually pick the Crown, pick up the phone and talk to the one we want to meet with. So we're often successful in doing this. And there's just a whole host of ways of dropping this. I mean, there's illegal searches where the search warrant's invalid. They stop a person on the sidewalk. It's not a valid search. Circumstantial evidence is weak about who had possession. Situations in a vehicle where 5 people are in the vehicle and we don't know who had possession. I mean, I could go on and on. There's so many defenses to drug charges. I guarantee that if you hire our law firm, we're going to find them. We're going to point them out to you, and we're going to approach the Crown on the ones that can't be fixed to try and wrest the best possible deal to avoid a criminal record. And if we've got a winning case and the Crown's not willing to play ball, we're going to vigorously fight for you at trial and try and win your case. So that's how to get a drug charges dropped. I must say not every case has flaws in it, but you'd be surprised at the number of drug charges that come across my desk and our other lawyers' desks over many years where we go, wow, the police made some serious errors here. They're not fixable. And I can get the Crown probably to withdraw this charge or at least get diversion and worst case scenario, a conditional discharge. So that's how to get a drug charge dropped in Ontario. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.